Bruce, 5 minutes.
Thank you, Mr. Chair. Mr. Sims, I held a hearing as chair of the Water Subcommittee of Natural Resources up in Richland, Washington back in June, and it became apparent that from the testimony of some of the witnesses from various government organization agencies that we weren't going to get the straight of what was really going on, and that is a blatant attempt to circumvent congressional authority to breach or remove those 4 lower Snake River dams. And by blatant attempt, I mean an attempt to use operational neutering, as I've chosen to call it, of those 4 projects, as opposed to actual breaching of the dams. That seemed to be, that was the conclusion I reached in that hearing. Can you comment?
Well, good morning, Congressman Bentz. Thank you for that opportunity to respond. The situation in the region is exactly as you described and what has been provided by testimony and others. These dams are being hobbled operationally. The folks that are pushing an agenda for their breaching or the removal are trying to make them less significant, less operationally significant than what they have done historically. And I think that has been an effort by folks to be continued on a single focused path of breaching or de-optimizing them, no matter which way they can work that. And you're right, Congress does have the authority, and I appreciate you as a member of Congress stressing that authority. It's been affirmed by both the Democrats and the Republicans that Congress is the single writing authority on those lower Snake River dams and the dams in general and their authorizations. I'll conclude by saying that there is an established record by the U.S. government, the Columbia River System Operations Environmental Impact Statement issued in September of 2020. And that was the U.S. government's view after an exhaustive multi-million-dollar effort involving stakeholders across the basin, that those dams can and should exist with some very minimal efforts and investments around them, because of course we are paying the world's largest Endangered Species Act mitigation program currently, and that was and is the government's record that stands today, despite the shenanigans from CEQ.
Right, and the shenanigans are being driven by CEQ, as you just said, as I understand it. But that was certainly not clear from my questions to, I think it was NOAA and Bureau, or Corps, I think it was Corps that was there. And there seemed to be a huge reluctance to share with the public exactly how this incredibly important decision to the Northwest was going to be made. Do I have that right, that this is being conducted in secret, this attempt to operationally destroy those 4 projects? And that we'll learn, I guess, when Judge Simon issues his order, if he does, on October 31st. And so how can one justify, if you're part of the CEQ, such an approach to such an incredibly damaging activity in the Northwest?
Well, sir, it's a great question. I would say I'm not standing in the shoes of CEQ, and having been witness to 25 years of federal, state, and regional process around these federal facilities and around the power system in the Pacific Northwest, it's incredibly difficult and very complex and requires the involvement of a lot of stakeholders. That's typically how we have moved policy in our region, is by transparent involvement of all sectors, making sure that folks are read in and understanding where things are headed and when they have a voice. And that has been completely the opposite, unfortunately, in the situation with CEQ. And as I outlined in my brief comments today, but also submitted comments, the NOAA report that CEQ had a hand in and has essentially put its basis upon is completely different than the decades of NOAA research and science on these issues to date. And we believe that has been the fuel, essentially, for the CEQ fire to burn down our region and effectively sidestep any kind of public process.
Right, thank you for that. And Mr. Lewis, what in your opinion is the most egregious expanse of CEQ power under the Biden administration?
What specifically is, sir?
Yeah, just give me one. Give me the one you think is the worst.
Well, I believe that having walled off...
Actually, it was actually for Mr. Lewis.
Oh, I'm sorry.
That's okay.
Pardon me, thank you.
Yeah.
I'll yield to Mr. Lewis.
Sure.
And use of power. Well, sorry. I'm not sure I can give you an example, because I'm not really following CEQ's actions with respect to particular projects or locations the way Mr. Sims is. He's really the expert here. I was looking at the abuse of power that I was looking at was the way they are trying to stretch a statute that was never intended to be a framework for climate policy into such a framework. And I mean, it's well known that NEPA does not even require agencies to elevate environmental concerns above other considerations when they deliberate on whether or not to grant a permit or approve the construction of a project. And here, what I'm finding is that CEQ wants to elevate the president's very specific climate goals and commitments, which are not commitments in law, but just of administration policy, into a make or break factor for deciding on whether projects should be allowed. I mean,
And we're going to have to stop there.
Okay.
My time has been exhausted.
okay.
Thank you so much.
Yes, that's